As a small business owner, sometimes it feels like no matter how much planning you do, there's always surprises, like an urgent, expensive repair. But here's a surprise you will like. With Progressive, small business owners save 13% on their commercial auto insurance when they pay in full. So enjoy a surprise for once. Get a quote in as little as 8 minutes at progressivecommercial.com. Progressive Casualty Insurance Company and Affiliates. Discounts not available in all states or situations.
Hi, I'm Juliette Cowley, a retired FBI profiler and host of the true crime podcast, The Consult, Real FBI Profilers. If you're fascinated with true crime and criminal profiling, then join us as we discuss real cases and examine the behavior exhibited before, during, and after the commission of the crime. You can listen to The Consult wherever you get your podcasts. It's as close as it gets to being in the room with the FBI's Behavioral Analysis Unit.
I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Welcome back to the Prosecutors Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my procrastinating co-host, Brett.
Why do it today when you can do it tomorrow, Alice? That's what I always say. You know, when I was still a prosecutor and defense attorneys would ask for additional time on their briefs, I never said no, because my position was, I could get hit by a bus before you finish this brief, and then I'll never have to write the response. So you take as much time as you
That's dark.
want.
That's a dark way to think about extensions. I did just have a meet and confer today about trial schedules and like all the deadlines that come with trial schedules with the other side. And they're like, can we do this and this and this? And I'm thinking, by the time we have this trial in March, I could be dead. So sure, why not?
Yeah,
give me 5 days to respond to that motion for summary judgment. Who cares? I might be dead.
Exactly. And then you never have to do it. So that's the value in procrastinating.
That's one way to procrastinate a deadline, is to die.
Which, by the way, if a judge dies, this actually came up. So
it happens,
we're about to talk about court cases.
Not infrequently
in the Ninth
because of
Circuit,
the whole lifetime appointment thing.
There was a Judge Reinhardt who famously did not believe in the Constitution and thought he was a king. He had written an opinion, and then he died before he issued it. And then his law clerks finished it up, and they issued the opinion. And the question became,
a legitimate?
Is that a valid opinion?
No, I was going to say no. But when I was clerking, there was a judge who was literally 98 years old. Still, he wasn't active. He was senior, but senior who had a pretty full load. Senior just means you're not retired. You still get to hear cases, but technically your seat becomes vacant. So a new judge can take that position, but you can basically choose what you want to do. You can listen to 0 cases or listen to all the cases. And he still showed up. I think he just wanted to go to New Orleans to party a little bit. But the reason we're talking about procrastinating judges or procrastinating in general is nothing like a good deadline to make the mind really come into focus and decide hard issues, right? Because, as you may know, now that you have followed multiple seasons of SCOTUS, we are really within the last couple days of the term. Now, the Supreme Court can do whatever they want, but typically this Friday would be the last day in which they would issue their opinions from the October term, which started October of 2025. But, Brett, shockingly today, a Wednesday, an opinion day, we thought, biting our nails, there must be something. Transgender athletes? Perhaps election law? Perhaps Humphrey's executor? So many to choose from. Something must come down today. But alas, Brett, what was the massive case that came down today from the Supreme Court?
Well, they released 5 cases today, so I guess as far as numbers go, that's pretty good.
Running towards the deadline.
There was a case on tax sales of property.
Everyone's favorite.
That was riveting. Everyone's favorite. I mean, it was pretty...
It's pretty dry.
Pretty light on substance.
Especially when you consider there are still, is it 12 more cases? 12 cases
and they're big ones.
That will be coming out maybe in the next 2 days, maybe not. I guess they're kings of their branch. And so, who's going to force them to? But presumably by Friday, Brett and I are going to be together. We might just be live tweeting from wherever we're hanging out.
I think they're gonna end up having
A Monday.
an opinion day next week. I could be wrong.
It's just too many.
Maybe they're gonna dig a bunch
like
of these
I was
cases.
kind of joking just now. These are the meaty cases, and if they're waiting until the very end of the term, historically, cases that come out on like the last day of the term are typically pretty contentious. And so they're typically not 9-0 cases, because if they were 9-0, they would have reached agreement pretty quickly. They would have all signed off on opinions and it would have come out already. Likely, we're looking at like 5-4 opinions coming out on Friday.
Yeah.
12 of them. And if they're going to be 5-4 as you follow these cases, we're probably going to have dissentals and the like.
Now, I'll say this. A couple things about this. Number one, this is where you really benefit from being a patron, because you're going to get our opinions before they come out. If you're listening to this live when it comes out, you get to see whether we correctly called these, because surely they will have been released
They have
by
to.
then. That's the first thing. The second thing, a few of these, it is 12, but there's at least 2 sets of cases where I think they'll be decided either together or very close together. I mean, there's the transgender athletes case. There are 2 cases that are basically the same. So presumably those will be essentially the same. So we'll see. But we're going to go through these cases. We're going to tell you what's left. We're going to give you our prediction on how it goes and what the vote count is. Maybe even who writes it, depending on which one it is. We'll see later on whether us throwing darts at a wall.
This is so fun. This is so law and nerdy. Okay, well, let's start with the first one, because this is kind of a pet favorite. I think of most of us who worked at DOJ, which is to say Trump versus Slaughter. And if you're thinking, I have no idea what you're talking about, it's because you probably have heard this case talked about as if this is the case that's going to overturn Humphrey's executor. So the question in this case is about independent agencies. So it's whether the statutory removal protections for members of the FTC, Federal Trade Commission, violate the separation of powers, and if so, whether Humphrey's executor versus United States, which was a 1935 Supreme Court case, should be overruled. And the idea behind that is whether there should be a, quote, unitary executive, whether the president, head of the executive branch, can have complete power over everything that happens in the executive branch, and the FTC is an agency within the executive branch. And the second issue is whether a federal court may prevent a person's removal from public office either through relief at equity or at law.
Yeah.
It's a meaty one. It's a meaty one.
It's a meaty one. And this is an important one. Basically, there was this period in the early 20th century where people decided this whole democracy thing, we don't really believe in that. and we don't really trust voters, and we don't really trust elected officials. So we want experts to be in charge of various things who are sort of appointed, and they're isolated from political influence. And we're going to do that. And so you have all these executive agencies that were created that have these what seem like bizarre protections. Like, why is it that the least accountable person in the government is a member of the Federal Trade Commission? It's a weird thing. And there's been a pushback on that really since it started, but it's gained steam recently. And I think Humphrey's executor, it's definitely on its
last legs. It's been on its last legs, to be fair, for a long time, but no decision has gone the distance. And the Roberts Court has gone the distance on several doctrines that have come close to the edge but never been pushed off the edge, like Chevron deference, for example. So,
yeah, and they've narrowed this consistently in the last few terms. So I think this is probably the case that's going to overturn Humphrey's executor. Though, just skipping ahead, I think it's worth discussing Trump versus Cook in the same breath, because that's a case whether the Supreme Court should stay a district court ruling preventing the president from firing a member of the Federal Reserve Board of Governors. So that's a similar thing, but the Federal Reserve is like the ultimate independent agency. And if you listen to the arguments in Trump versus Slaughter, it seemed pretty clear the court's going to say president can absolutely fire a member of the Federal Trade Commission. But when it comes to the Federal Reserve, and I personally didn't really appreciate this from the court, like there was so much talk about the effect well, what about, what's the effect going to be on the economy and all this other stuff? And look, I understand those are important practical considerations, but at the end of the day, if the Constitution doesn't allow it, the Constitution doesn't allow it. So even if you think like this is the best way to do it from an economics point of view, that really shouldn't be what you're deciding. But it really seemed like a lot of the same justices who were going to be fine with getting rid of federal trade commissioners, allowing the president to do that as his prerogative under the Constitution, are not going to say the same thing when it comes to the Federal Reserve. So I'm really curious how they're going to square that circle. Like, how are they going to say, on the one hand, yeah, Humphrey's executor is unconstitutional, but on the other hand, when it comes to the Federal Reserve, it's different. It's just different.
You mean the Supreme Court would need to square a circle the way they did with Calais and Milligan? Oh, no, certainly not in voting rights. But one thing to know about this, I have not factored in who wrote the 5 opinions today, but typically the way opinions are assigned by the chief, if he's in the majority, is as evenly as possible. So obviously you have to be in the majority to write it, but generally that's how you can kind of, at least by odds, see like who might be writing opinions. And so far, Roberts, Alito, and Kavanaugh have written the fewest opinions. I don't know who wrote what today, but before today, they each wrote 2 opinions only of what's been released, meaning that they are going to write the majority of the remaining cases. And Sotomayor and Jackson, both before today, had written 6 opinions each. And I think Kagan had written 5, which means that of the quote-unquote liberal justices, they're likely to write fewer, much fewer, like a quarter of the remaining cases.
Yeah, and these are issues, all the issues we're going to talk about today are issues that are very important to the conservative justices and that have divided them before. They're going to write all these opinions.
That's probably why there's so much jockeying, because there's going to be a lot of concurrences and concurring in the judgment, but not the reasoning.
I think the Chief Justice or
Kavanaugh, we know how much Kavanaugh cares about Humphrey's executor being overturned. It's like his rallying cry. So, of course, the Chief Justice gets to decide, and he may want to write it. But if Kavanaugh had his way, it would be overturned, and he'd be writing a rallying cry. If not, he's going to write a very strong concurrence.
I kind of wonder if Kavanaugh will write Slaughter, getting rid of Humphrey's executor, and then
Cook will be the chief.
The chief will write Cook.
I could see that.
Sort of bringing it back.
We're bringing it back. Okay, tamp it down there, Kavanaugh.
yeah, like just sort of a very narrow. I mean, they'll have to work together.
That would be the very chief, right? Chief is all about like institutionalism, and so it's like, don't worry, the sky isn't falling just because we come out this way in Slaughter, where Humphrey's executor is overturned. I could see that. Yeah,
that's one thing that'll happen. Obviously, these will be 6-3 decisions, maybe 5-4 if Amy Coney Barrett gets like a wild hair about her. But
she does do that. It's very fun.
She does. The liberal justices will definitely be in the 3.
They will probably be writing dissents that are strongly worded as well.
They're probably going to write a lot of dissents.
They're probably writing in all of these, actually. They actually probably, if they're not writing the majority, they're writing a dissent in all of them.
Which may be why it's taking so long, because they may be waiting on the dissent to
That's actually a great point. And speaking of cases that are really boring that no one's going to care about, Brett, campaign finance. Am I right? Who cares about money and campaigns? Okay, so another case that was argued back in December, still hasn't been decided, is National Republican Senatorial Committee versus FEC, Federal Election Commission. So this is about whether the limits on coordinated party expenditures in Statute 52 U.S.C. 3116 violate the First Amendment, either on its face or as applied to the party's spending in connection with quote-unquote party coordinated communications as defined in a regulation, 11 CFR 109.37. So the age-old question that the Supreme Court has had to weigh into many a times.
This one's pretty straightforward. I mean, so basically at this point, the Supreme Court has struck down every provision of McCain-Feingold except for this one, and this one doesn't even really make sense without rest of McCain-Feingold, because it's basically this idea was you don't want coordination between the campaigns and between independent groups like 501c4s, whatever they are. Anyways, the super PACs, basically. Didn't want coordination. Things have gone totally off the rails with this. You've got situations where you've got these super PACs speaking for candidates, but do they really speak for the candidate? Now candidates can kind of hide behind the super PAC and say, look, that was a super PAC put out that ad. I didn't have anything to do with that. I can't even coordinate with it. Some backdoor getting around, like firing your campaign manager who then goes to head the super PAC so that they can sort of do the campaign to the super PAC. Really just doesn't work. And it's going to be struck down. It's going to be 6-3 probably. It's going away. This is easy peasy. I'll be shocked if it goes anyway other than that.
Maybe Alito on this one. I was thinking the chief and Kavanaugh, I think, will write the Humphreys executor. Like one of them will. And then I think when we get to the transgender cases, I think Kavanaugh will write that one, which is why I'm like,
I actually think it'll be Gorsuch.
okay, it could be Gorsuch.
I have reasons for that.
Okay. No, that's fair. So I was trying to think which one would be Alito. This was more by process of elimination rather than anything else.
I could see it being Alito. I could see it being Barrett.
Okay.
This is just sort of
again, that's only because Alito's written fewer opinions. That's why I'm like doing the little process of elimination in my head.
And he's got to be saving up for something, right?
Right.
So, okay, well, we'll see.
We'll see. So while I think that Cook and Slaughter will be two separate opinions, I actually, and I don't know, we haven't talked about this at a time. I think, so there are two transgender athletes cases before the Supreme Court, Little versus Hecox, and then West Virginia versus BPJ. I actually think they'll issue one opinion in this. They're argued the same day. Generally, the questions presented, biological males, can they compete in women's sports? And it's under like the 14th Amendment and Equal Protection Clause. So everyone knows it as the transgender athletes cases. I think one opinion will be issued in both cases because of the arguments being on the same day. And you think it's Gorsuch. Why do you think it's going to be Gorsuch?
Yeah, so I mean, basically, this is going to be a case about whether or not states can require people to participate in sports based on the gender of their birth. And I think it's going to be Gorsuch because Gorsuch wrote Bostock. Bostock was a case about, there's a federal statute that prevents discrimination on the basis of sex. Bostock was about someone who was fired because they were transgender. The question is, was that on the basis of sex? Gorsuch wrote this opinion saying it was and sort of laying all this out. The way it's written is supposed to be pretty narrowly written. But of course, I mean, like everything the Supreme Court writes, it's been very broadly applied. The states have sort of struggled with how to apply it. Different states have gone different ways. Gorsuch has received a lot of criticism from his friends on that. It was not a decision that was popular with the people who nominated him and confirmed him to be a justice. I'll just put it that way. So I think Gorsuch will probably look for an opportunity to clarify and limit Bostock. This case presents that. And so I think Gorsuch will end up writing for a 6-3 court saying that states can pass these laws and these laws don't violate the Constitution. I think that's what will end up happening in this one. And I'll note, Gorsuch also wrote the Childs versus Salazar case, the conversion therapy case. So
really carving out a niche here for himself.
Yeah, Indian law. He loves Indian law.
There you go.
I don't think we have any Indian
Well, I was going to say, we may not have Indian law, but, you can't have a term without a Second Amendment case. It actually is kind of amazing. I'm like, how do we have another? Yeah. We have multiple Second Amendment cases every term. Like, just right to bear arms. But boy, does it spawn some litigation. So, of course, we do have a gun rights Second Amendment case that is still pending. This is Walford versus Lopez. And it's one of the Supreme Court's favorite circuits, the Ninth Circuit. I say that a little jokingly because those of you who have followed previous seasons of SCOTUS know that the federal court of appeals that gets overturned the most is the Ninth Circuit Court of Appeals. Some may say that they're just ambitious. They know where the law is going to go, and so they kind of go out on a limb and oftentimes are overturned. But in this case, the Ninth Circuit held that Hawaii may presumptively prohibit the carry of handguns by licensed concealed carry permit holders on private property open to the public unless that property owner affirmatively gives express permission to the handgun owner. So the Supreme Court is reviewing whether the Ninth Circuit erred here. As with kind of all these gun rights cases, it's like, how much can you limit? And this is like the private and the public and the concealed carry, who has rights where, because we obviously have private rights. And then you have it private land that's open to the public and what that means here.
Yeah. So basically, the problem with this case is going to be that the presumption is it's prohibited. Supreme Court's going to reverse that. They're going to say private property can prohibit people from bringing guns onto the property. If you're an owner of property, of course you can do that, but it's not going to be the presumption. You're going to have to take an affirmative action to do that. That's what they're going to say. That's not what's actually interesting. What's interesting is the why. So the Supreme Court, since it recognized a private right to bear arms a while ago, has been struggling with how exactly to apply the right. And they've gone through a couple different formulations. They're currently on this, what I think is a very strange, difficult to implement. Is there a historical analog statute at the time of the founding? Doesn't have to be an exact analog, but is there some sort of analog? And so what you see, if you paid attention to the marijuana case that came out, I think last week, it was about whether or not someone who's an occasional user of marijuana can be charged with possessing a firearm while being addicted to drugs. That's illegal, and it's still illegal. But the court said an occasional user of marijuana is not enough. And there was all this argument about, well, there was a statute back in the time of the founding that was about drunkards and how drunkards, couldn't have a gun. And the whole argument was, is using marijuana occasionally the same thing as being a drunkard? And if it is, does that mean they can ban it? And there's this line in the opinion that was like, oh, that was different people for different reasons. It's like, well, yeah, but you asked us about analogous. Is it analogous? So what does analogous even mean? They've got to fix that. That standard doesn't work. I mean, I'm not exactly sure how they should do it. I mean, I feel like they should just look at it just like the First Amendment. I don't understand why they don't just do the same review they do of the First Amendment, which is reasonable time, place, and manner restrictions. Otherwise, you're free to do whatever you want. I mean, to me, that seems the way you do it. Not this whole, the Second Amendment is not special. It's not a second class right, but it's not a special right either. So just treat it like you treat all the other rights when you look at these laws. But I don't know what they're going to do, but I feel like this is an opportunity for them to clarify that. Now, Justice Thomas has written recent Second Amendment cases, but I feel like his view on the Second Amendment is not supported by most of the justices. And I feel like this might be an Alito opinion. I feel like Alito might write this one sort of trying to clarify and bring harmony to all the different Second Amendment opinions that we've seen over the last few years. And obviously, this one will be 6-3.
Harmony of Second Amendment opinions. If only this could be the one clarifying opinion. Nevermore shall we have more Second Amendment cases. Yes. That's your prediction. No, I'm just kidding.
No,
I'm kidding.
No,
I'm kidding. I'm kidding. That was me being facetious. That was me being facetious. As you can tell so far, I mean, basically any hot button issue you can think of is still left. And you might be thinking, I'm exhausted from all the controversy that's about to come. There surely will not be more. There's going to be like an easy peasy case coming up, right? Well, sure. We have more election law, as if this season of SCOTUS wasn't exciting enough with Voting Rights Act opinion in Calais, which they held over from last year. We still have another one, Watson versus Republican National Committee, the RNC. So this is really interesting. Back in 2020, remember when we were all holed up and a lot of people, most people, I think, were not going to public places? Well, we still had to vote. And so Mississippi passed a law that said that you could mail in ballots and they would still count as long as they were postmarked the day of the election and received within, I think, 5 days of the election day. So the question here is whether the federal election day statutes preempt Mississippi's state law that allows ballots that are cast by federal election day to be received by election officials after that. And this is really interesting because the Constitution provides, quote, the times, places, and manners of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. So this law went into effect. The district court judge was like, yes, agree, this law can take place. The Fifth Circuit, where Mississippi sits, actually overturned and said, no, you cannot have this law where these ballots are coming in willy-nilly after the date of these federal elections. And now the Supreme Court reviews.
By the way, I just looked it up. None of the opinions that came out today were by
the three.
Roberts. So Roberts is going to be writing a lot.
Which also tracks, though, because, I mean, if I were assigning opinions, I want to assign myself the fun ones, too.
And just to give you an example, we said these final arguments, these final cases, the arguments are really between the justices on the right. So we've said before, I really feel like this is a 3-3-3 court. And you've got Barrett, Roberts, and Kavanaugh in the middle, Gorsuch, Alito, and Thomas on the right. Gorsuch and Kavanaugh swap sometimes. Sometimes Kavanaugh is on certain issues, he's on the right, and Gorsuch in the middle. Roberts and Barrett tend to be pretty much in the middle. The people who argued this case. So you've got the Mississippi Solicitor General, Scott Stewart, the same Mississippi Solicitor General who argued Dobbs, which overturned Roe versus Wade, arguing to defend the statute. You've got Paul Clement, who's former Solicitor General, who's always there, is representing the challengers. And then you got the Solicitor General weighing in as a friend of the court, saying that Mississippi should lose. So very much an argument amongst friends in a way about how this is going to go. And this is one of those things where ordinarily at the common law and everything else, there's a sort of mailbox rule where if you put it in the mailbox before it's due, you're good. It didn't have to get there before it's due. And so that would be sort of the standard rule. Now, of course, this is a statute about election law pursuant to the Congress's power to order these things. And it seems like the court is going to say that the ballot has to get there by the day of the election, not you have to put it in the mailbox. Feels a little strange because putting it in the mailbox feels like voting. I voted on election day. I put it in the mailbox. One of the issues that I think Mississippi's defenders are obviously going to have is there's been so many shenanigans in the last few elections about this whole thing, when ballots come in and when they're postmarked and harvesting of ballots and all this stuff. And even if you don't think those are legitimate issues, there's been a ton of press about it. I feel like that hurts Mississippi. And I think even if ordinarily it feels like putting it in the mailbox should be enough, Congress gets to say, and even though they're not explicit on that, I think this is going to go 6-3. Probably, who's going to write this one? I mean, this could be another Chief one. He has written so few. He could write this. I mean, Barrett's only written...
She's written more.
Barrett's written a few.
Only a little bit more, but...
I mean, it could be Alito. You're right. Alito's written very little. I'm going to go with Alito just because I think the Chief's going to write some of these other ones. Well, I don't know. We'll see. And if we're wrong, obviously we could be wrong.
The assigning,
he could go a little.
I think we're going to be not spot on. Well, yeah, I do. I think we're going to be spot on in how they come out. But as for writing, some of it is a little bit of a guess, you know.
We will miss one of these on how they come out. There will be one of these at least that's a surprise, I think. So maybe that one will be written by like a Kagan, but you know. But I'm glad you're so confident in our ability to predict this.
Just
one of our haters on Reddit
just based
said,
on what do I Reddit? What is Reddit? I'm just kidding.
One of our Reddit haters said they hate our podcast, but they always listen because they want to know what Supreme Court's going to do.
Imagine that. What does that say about us?
Like, Sorry.
It's hard to be right. It's because we read these cases all the time. It's not voodoo. It is just being steeped within these arguments for a long time. Okay, talking about being steeped in these arguments of non-controversial cases whatsoever. You're thinking Second Amendment, transgender athletes, election law. What more can we do? Why not throw in immigration law? So, yes, of course, there's still an immigration case. There were a lot of immigration cases this year. One of the many immigration cases left. Mullen versus Al Otro Lado, the other side. So it's whether an alien who stopped on the Mexican side of the U.S.-Mexico border arrives in the United States within the meaning of the INA, which is the Immigration and National Act, which provides that an alien who, quote, arrives in the United States may apply for asylum and must be inspected by an immigration officer. So this is a really interesting statutory interpretation case as to what does arriving in the United States mean. Do you actually have to cross the border? Or if you come up to the border, but on the Mexico side, is that under the definition of the statute arriving in the United States? Which you can imagine has really big practical implications.
Yeah. And so basically what's happened is the government at various times has essentially stopped people from getting to ports of entry. So we'll have INS agents in Mexico working with agreements with the Mexicans who basically will prevent asylum seekers from reaching the point of entry. The theory is if we prevent you from reaching the port of entry, then you don't have the same panoply of rights that you would have if you actually reached the port of entry. That's what they're doing. That's the argument that they had. And I mean, so the question really is going to be, do you go with the purely statutory interpretation? And if you do, government wins. Because they didn't get to the port of entry. So therefore they're not there under the statute. Or do you say because the government is physically blocking them from getting to this point, does that somehow create an exception to the statute? This is one of those where people, if you listen to the arguments, it feels like the government's going to win this one. That would be consistent with the general tenor of the Supreme Court's opinions on these types of questions. But I think this is one where it's possible it could go the other way, but I don't think it's going to. I think it's going to be another 6-3 issue. But I could be wrong on this one. I can imagine this one going the other way.
Yeah, I could see it going either way, but I tend to think, having listened to the arguments, that the government's position may rule the day.
And one of the problems with the other side was they were really pressed on, okay, let's say we want to have an exception. When does it start?
I was going to say, like, how far away? Like, what if you're an invalid and you're at home, but like your heart is at the border? Like, you know, like what does that mean? But really, I mean, this is kind of along the lines of the Mississippi law for election law. Like, how far does it go, right? Well, I intended to be there.
Or, I mean, imagine if they put the INS agents at the southern Mexican border and they're stopping people who are coming up from South America way down there, 1,000 miles away from the border. You know, does that count or not? But then the other arguments were, well, what if there's a long line and you're at the back of the line? The person at the front of the line is fine. What about the person at the back of the line? Or the person in the middle of the line? So there, it is a difficult line drawing
exercise, which, you know, we'll see. That'll be a really interesting one to read and to see what they're rooted in, like statutory text, legislative history, literary text of what it means, or practicality, like what does it mean to arrive? What's the, like, you know, existential definition of arriving? Have we all arrived? Where are we? What is life? Okay. Anyways,
why am I here?
Like Brett said, that was not the only immigration decision. I got confused here because I thought we already dealt with this last term, but I forgot that there was another temporary protected status, the TPS program. They exist for like different populations, and the Trump administration had ended this TPS program for Syrian nationals, you may remember. And the question is, can the president block this?
Yeah, and I feel like this is kind of in a weird place because I think it came to the court on a preliminary injunction. So it's a preliminary injunction question. We're not to the final yet. So you could imagine the court saying, we need more information, so we're going to deny it now. It'll come up later. I don't think there's any question that the government can end temporary protected status. And there have been some extreme district court opinions that have been very limited on the government's ability to do that. I mean, temporary is part of the name of the thing, right? I don't know. This is another one. I could see this one going in a more limited direction and not as definitive as maybe people expect. I'm not really sure what'll happen on this one.
Now I know nothing. Nothing.
You know,
I was going to say they would allow. I tend to think that they will allow the blocking, but
I think they'll
but
allow it to continue in the lower court and then eventually rule. Yeah.
But why is it taking this long? That I'm a little bit confused.
I don't know.
But you know, everyone has to procrastinate a little bit. That's the only reason. This is also just shaded by the fact that these cases have been kept. Because when was that case argued? That case? Oh well, it was only argued in April. Never mind. They just argued it.
Yeah,
so
it's a relatively
it may just
recent
be
one.
that they barely have the papers in. Okay, what do we have left?
Maybe that will be 9-0. Maybe they'll all get
that's
together
their
on
one
that.
kumbaya.
So.
And Sotomayor Jackson will write that. I don't know. Okay. Oh, one of our favorites, of course. If you've listened to Legal Briefs, you are probably an expert on geofence warrants. And here we have it. This was percolating when we were prosecuting and using geofence warrants, Brett. So in Chartree versus United States, the question that a lot of you guys have asked, especially when we did the geofence warrant episode, said, isn't the execution of a geofence warrant violating the Fourth Amendment? And that is the precise question before the Supreme Court.
So I listened to the arguments on this case, and I was annoyed the whole time. I was annoyed by everybody involved. I was annoyed by the advocates. I was annoyed by the justices.
Because they hadn't really used geofence.
They had no idea what they're talking about.
They had no idea what... I actually stopped listening to the arguments because I was like, you don't actually know what a geofence warrant is.
And that's one of the problems with the Supreme Court.
And I want a geofence warrant when I am Nancy Guthrie getting kidnapped, by the way.
Exactly.
I don't care what constitutional amendment you think it violates. I want you to get that geofence warrant and find me.
Justices are dilettantes, in a way. They might have expertise in a certain area, but they don't have expertise in every area of the law. And one area where they have very little expertise is anything like this, criminal law, this kind of stuff. And they're so just pie in the sky.
Only Sotomayor has been a prosecutor. Was Alito?
Only Sotomayor.
No. Kind of, for like a day.
Like 50 years ago.
Sotomayor was also a very long time ago. So, I mean, I do think being in the ivory tower for a while, you like lose touch of remembering what it's like to get those calls in the middle of the night where a child's been kidnapped and you've like run out of leads and you're like fighting against time to save the child's life.
I mean, we're talking about something where if you've ever picked up your phone and used Google and Google Maps, the first thing you have to do is agree to share the information. It's the first thing you have to do. So traditionally, that's it. It's over. You lose. You've put this information into the public. It's no different if you walk over to the park and shoot someone. You don't get to claim some right to privacy in what you were doing in the park. It's just stupid. If you drive your car with a kidnap victim and the police are following you, guess what? You don't have right to privacy in your public movements. If you have a sign hanging out your car that says, I'm doing something illegal. If you call your bank and say, hey, I need a loan so I can buy some drugs. Anything you do where you're putting it out into the public, it's not a private issue. It's not subject to a warrant. And traditionally, this has been easy. Then comes Carpenter. And Carpenter, you just want to find the agents and the U.S. attorneys who were involved in that case and slap them because they were so stupid. And I hate when people do stupid things because they basically tracked this guy's phone, every movement he made for months without a warrant. So, of course, it's the worst possible factual situation you could have. It goes to the Supreme Court, and Chief Justice Roberts, God bless him, he has no principles. He just does whatever he thinks is right. And he just saw that, and he was like, I don't like this. I don't like that they could track you. So he sort of invents this constitutional right in Carpenter, which he then turns around and says, but it's limited to this very specific circumstances. And from that point forward, the government's position has been, you don't even need a warrant usually when you're doing that because of all the traditional rules. It's just when you do something really stupid like they did in Carpenter, then you need to go get a warrant. In this case, they got a warrant. That's what's crazy about this. Not only is this publicly available information, but they went out and got a warrant to search this information. And the argument's so stupid. It's like, well, they got a warrant at step 1. Should they have got a warrant at step 2? And this is what they do. They create all this procedural BS. They paper over this stuff to make themselves feel better, which just makes it more difficult to have a criminal investigation. Doesn't actually protect anybody's rights. And but it makes them feel good about themselves. So I could imagine them saying it's a 3-step process and you need a warrant at every point. I could imagine them saying something like that. I think this one could be 5-4. I think Gorsuch could be just against this altogether because he doesn't believe in criminal law. You could imagine 6-3 or even 7-2 with the court trying to somehow limit these things. I mean, I don't know. I feel like Roberts probably has an interest in narrowing Carpenter. Because I think he's seen the criticisms, and this happens so often. This is why I think Gorsuch is going to write this. They write these opinions, they see what happens, and they're like, that was a little bit further than I wanted to go. And then they come back and write the next iteration and cabin things. So I could imagine Roberts writing in this case, or even dissenting to say Carpenter didn't mean this. So this one, the oral argument was completely unilluminating.
Because I don't think they knew. Maybe in the interim, they have learned more about geofence warrants.
And it was like, whoa. And the defense attorney keeps saying, well, when they did it, there were people in a church and they were searched. There was somebody in a house and they were searched. And it's like, okay, well, those like foundational law, you don't get to advocate for their constitutional rights. You don't have standing to make those arguments. But it was trash. The whole argument was trash. Don't listen to it. It's a waste of your time.
The penultimate case is Monsanto Company versus Durnell, it's a case about whether is it FIFR, Federal Insecticide, Fungicide, and Rodenticide Act, preempts a label-based failure to warn claim where EPA has not required the warning. I don't know how this is going to come out. It's a failure to warn
case. This is the Roundup case. You're probably familiar with the Roundup case. Glyphosate is in Roundup. Apparently causes cancer. So there's no warning on it about it. But someone sued and said, hey, you didn't warn me about it. And Monsanto's defense was, we're not required to. And this is the problem with regulation. Because on the one hand, regulation...
You think it sets the floor.
Yeah, but it really sets the ceiling.
Because if it's...
And that's the question here. Is it by regulating in this area that you foreclose the ability to pursue this? And Monsanto, I mean, look, they don't have a terrible argument. If you're going to regulate us and you're going to tell us we have to do all these things, don't then turn around and say we can be sued if we don't do a thing you didn't tell us we have to do. So, I don't know. It is the downside of regulation. We'll see what happens. I think probably the court's going to side with Monsanto.
I think because regulations set the ceiling, not the floor. Because then where do you go?
It's a preemption. Right. It's a preemption argument at the end of the day. So, yeah, it seems like it's preempted. Otherwise, the regulations become, like you said, I mean, it's just, if you're the company, you no longer have a safe harbor in we complied with the regulations to the T. And typically you do. Typically, if you comply with the regulations to a T and then something happens no one anticipated, that's sort of a defense. So we'll see what happens. I think this one probably goes Monsanto's way. This one might be one that's a little bit more quote unquote bipartisan. We'll just have to see. This was another one where Clement's arguing all the time. He was there. So
actually, didn't he? This is not an exaggeration. I think he argued a dozen cases of the like 70 or 80 cases argued this time. I mean, he was there. He's argued. He now, I think, has argued more cases than anyone else living. Or ever, actually. There used to be someone at DOJ who had argued more because he was a civil servant in the Solicitor General's office and did a ton of cases, big cases and like the less controversial cases. Ed Needler at one point had argued the most number of cases. Great guy to work with, by the way. But I think Paul Clement now has eclipsed everybody. He is the SCOTUS advocate.
And he was there for Monsanto.
So. Okay, so I totally left this out because it's such a nothing burger. Birth... right? Citizenship. I'm sure all of us forgot about it because what's the big deal? I totally thought birthright citizenship was going to be one of the last cases, but I didn't know it was going to be one of a dozen cases left at the end of the term. We talked about birthright citizenship a couple times on Legal Briefs. You can go back and we talked about it after the argument. We talked about it before the argument. But that is certainly, okay, so of course is whether... This is another one.
Yeah.
This is not how I categorize things in my head. That's why. And we've talked about this case at length as to what we think is going to happen.
So one thing, I don't know, I've gone back and forth on this. I think I'm at 7-2 now.
Okay.
I mean, okay, the executive order is going to be struck down. I think it's possible they don't strike it down as to birth tourism. And I think it's possible they strike it down as beyond the president's powers to act alone, given the authority the Constitution vests in Congress. I wish they would do that. I think this is an issue that's important enough and divisive enough and has enough different aspects to it that it probably should be the subject of some sort of congressional debate, decision, that sort of thing. So I would personally prefer if they didn't just decide it for all time, which is what happens when the Supreme Court decides something. But There's no way the administration wins. I think 7-2 with Alito and Thomas in dissent. But here's the other thing. We're treating this like this is how it goes. In reality, like I was just looking at a case recently where it was so divided that no one can figure out what the majority is. And there were people arguing that the dissent was actually in the majority because two people putatively in the majority agreed with the dissent's reasoning on something. And so therefore they were actually in the... So like in this, you could have it be like 6-3 for the administration on birth tourism, 7-2 against the administration on other situations, or like Thomas joins part 1 and 5 of the opinion, but not parts 2, 3, and 4. I mean, you could have something like that happen. So I think the chief writes this one, right?
Yeah. Oh, yeah.
Seems like
this is the chief's
going to write this one. Just to confirm, so Roberts, Alito, Kavanaugh have written 3 opinions. Everyone else has written 6 or 7. So 9 of those opinions are probably going to those people, maybe more. You know, it's going to be interesting to see what happens. But I think 7-2 for the main question here. What do you think?
Yeah, I think that's probably right. The tourism was such a point of contention at oral argument, and it's such like an obvious give there. So I think that's right. And then this is a way to be able to not have like a 5-4 opinion. Yeah. Because it's already divisive enough. We don't want
birth tourism
divisiveness.
To me is like you were saying when we talked about it before, it's sojourners. To me, that one's easy. Right. And we'll just see what they do with the other stuff.
There you have it. Well, you will know within like 48 hours. Really, you'll know within like 36 hours whether we're wrong.
On some of these. I mean, there's no way they're releasing all 12 opinions on Thursday.
Did? And like they all read from the bench. Like Kagan's like, I'm just going to read every dissental from the bench. And we're there until like midnight. And it was the day the court went in infamy. I don't know. We'll see.
Yes.
I mean, technically Monday's still a June. It's June 29th, right?
I think they're going to release opinions next week. I really do.
I think they have to. Like the print. So they have to send these to the printers too, to like have them printed out, right? Like it takes time. There's like administrative stuff you have to do that I don't think there's enough time for. Because there's like, aren't I right about that? They have to send it to the printers. There's like a time in which they have to send it to the printers.
Well, they come out with boxes that have the opinions.
There's like one printing company in like the country that does this.
I mean, I think it's a little different for them. If you're a Supreme Court litigator, there's only like a couple that can do it. But
I just remember it being an administrative hurdle of like when the opinions had to be finished and sent off. But, you know, whatever. Again, they're the Supreme Court. They can do whatever they want. So anyways, let us know what you think. This has been and will continue to be an exciting season of SCOTUS. And then the justices will go on a vacation. Thomas will probably go around the country in his RV. And
Gorsuch should go to Italy.
Justice Barrett will probably continue a book tour of some sort for her new book.
Yeah. I think Alito has a book.
Alito might be on a book tour as well.
And this is assuming none of them retire. I mean, that could happen.
Maybe after this one, they're like, I wrote too many. 6 opinions in one day is too many. I retire. That's true. That could happen as well. Maybe they're waiting until the midterm elections. Well, this has been fun, as always, Brett. Look at us getting through 12 cases in an hour. I didn't know if we could, which is why I was trying to like keep us on our toes a little bit. But apparently I could have dilly-dallied a little bit. We haven't even hit 55 minutes. Wow.
It's brief.
This is the 3rd time we've recorded this week. So look at us. Look at us being efficient. Is there anything else you want to talk about SCOTUS?
I'm just ready to see what they're going to do.
When a lot of these drop on Friday. I wonder if it'll be, because Monday was a nothing burger. Tuesday? Monday and Wednesday have been nothing burger. Tuesday.
Today is Tuesday.
What? Oh, I thought today was Wednesday. That's why I keep saying in 48 hours.
You keep pushing us into Wednesday, but today is Tuesday.
Oh, Lord. 100. That's why I keep saying 48 hours, because I thought it was Wednesday. I'm completely wrong. We have like a whole 72 hours until we find out if we're wrong. This has been fun. And then we all get a break and we just get to talk about boring true crime. Actually, we'll probably analyze a bunch of these cases because all of them could be an episode in and of themselves.
They absolutely
Actually, that's probably what we'll do all summer is go through these 12 cases.
Yeah. That's probably what we'll end up doing. And what impact
well, thank you guys. It's always fun to analyze these cases alongside you. Hope you learned something today. And at the very least, as these opinions are dropped, you'll have a little background about what they are and how they might or might not come out and who's grading them. You have even that on top of all our analysis. Well, guys, this has been real, but we all wait with bated breath on what will happen at the end of this season of SCOTUS. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors' Legal Briefs.
Man, that Hannah Hill, she's got some great
Sure
art.
does. Actually, I was just thinking, I have a couple of her prints that I've yet to have framed. I'm like, I'm definitely gonna, I'm thinking about putting them like right when you walk in my front door. Because people, it will like,
Oh, that's awesome.
objectively, people will be like, that's a cool piece of artwork. I'll be like, Hannah Hill.
Yeah.
Hope she's
a real
listening.
blessing.
That she heard me say that.
Yeah. She just got married. So
Yes,
congratulations
she
to her.
did. How you doing?
I'm doing fine. Those of you who came to hear what important Supreme Court case came down
Which is
today,
to say, none of them.
the answer is none. None.
Hello, and welcome to Pluto Phone. If you know the name of the movie you would like to see, just stream it for free on Pluto TV, where all your blockbuster favorites are landing all summer long. Catch Anchorman, The Legend of Ron Burgundy.
Fantastic.
Men in Black, 1 through 3.
That's what I'm talking about.
Mean Girls.
Shut up!
Titanic.
I'm the king of the world!
And so much more. For showtimes, press nothing. They're free 24/7.
That is so fetch.
On Pluto TV. Stream now, pay never.